Hi, it's Mike DelSignore, Massachusetts criminal defense attorney. Today's video, I want to talk about what happens if you're accused of domestic assault and battery. What do you need to know? What's going to happen in court? So first thing you need to know is these charges aren't dismissed on the first court date. A lot of people think they are because your wife or your girlfriend, the alleged victim, is not on board. They didn't want you arrested. The police came in, they said they had to arrest somebody. That's good for the case because the case may ultimately get dismissed. It just doesn't happen on the first court date. What's going to happen, your first court date, you're going to enter a not guilty plea. We'll get a copy of the report, all the evidence, and then it'll be put on for pre-trial. And what we're looking for to establish is, can the government prove this case without any cooperation from the alleged victim? The alleged victim is not on board. The case, in many cases, will get dismissed unless there's a 911 call where there's an excited utterance, and the Commonwealth can potentially establish the allegations, the factual allegations, without putting the alleged victim on the witness stand. Now, this is something we can strongly object to because the Sixth Amendment to the U.S. Constitution guarantees you the right to face-to-face confrontation with your accuser. There's a sort of an exception to this right of confrontation if the statement is deemed to be non-testimonial. So this law is very subjective, but basically if there's a call to 911, the victim says, hey, my husband, my boyfriend, he's hitting me, strangling me, get an officer here. If that's made while the person is in the room, in the heat of the moment, that's likely going to come into evidence as non-testimonial because the court's going to say the primary purpose of the victim in the case was not to accuse you of a crime. That's exactly what happened, but to get help. That was the primary purpose. So that statement is deemed admissible, exception to the confrontation clause. Still something that should be objected to. Constitution's plain in its language, and many of the judges who are not great criminal defense that President Trump appointed are pretty good on the Sixth Amendment because the literal language of the Constitution says you have a right face-to-face confrontation. So these textual judges that have changed the Constitution and changed individual rights in a lot of different ways in this context could actually help you. So keep that in mind, that there could be an excited utterance. That's a legal motion. You'll have a hearing in front of a judge. That's something that would be heavily litigated if the government wants to proceed on that. I always recommend get any kind of counseling, treatment. If this was an alcohol-related event, deal with the issues that led to the criminal charge, because then maybe the government, potentially they could go forward with an excited utterance, but if the victim's not on board, they may say, okay, we'll agree to a resolution without requiring you to take the case to trial. Another thing that can happen in these cases, if there's an independent witness, then they could prove the case. So if the victim has a marital privilege, a Fifth Amendment privilege, but in many cases, even if the victim's just not on board and there's no privilege, the government will dismiss the case. But it's going to take time. It'll probably take you 4 or 5 months. They'll put it down for what's called the bench trial, with the idea that if the victim appears, then you'd still have a right to pick a jury trial. But generally, it's put on for a bench trial with the idea that the government is going to run into a roadblock in prosecuting the case, and the case will get dismissed. So hang in there. It's very difficult to have criminal charges pending. I've helped people for over 20 years with domestic assault and battery, criminal charges, make the best decisions for themselves. I'll guide you through the process, tell you what's going to happen next. You have your arraignment, your pre-trial, and I'll hopefully bring this to a resolution as quickly as possible so you can get back to your life, back to your family, supporting yourself. I know the strain of having a criminal charge. Domestic assault and battery, it's a misdemeanor offense unless it alleges dangerous weapon or there's a charge of strangulation. You can call, text me anytime at 781-686-5924. My name's Mike DelSignore, Massachusetts criminal defense attorney.